Okay. This is Akkad, I may be mispronouncing it, and counsel can correct me. Akkad versus Nebraska Heart Institute, PC. Judge Irwin is recused, and Chief Judge Inbody will be participating on briefs. Good morning.
Good morning, Your Honor. Thank you. I'm Dave Domina. I'm here on behalf of Nebraska Heart Institute, and I have pronounced the name Dr. Akkad.
Akkad.
So that's what I will say today.
Thank you.
Once upon a time in Douglas County, there was an office with physicians practicing medicine. There were 7 physicians. They were heart doctors. They did well. They had a staff and employees in an active and vibrant business until one day, 6 of the 7 doctors decided to quit in unison, leaving intact a practice of patients and equipment and records and people employed to support the 7 or 6 departed physicians. The patient load was too great for one, the records too extensive, the staff burden too heavy, the possibility of continuing practice was non-existent. The 7th doctor said, I want to stay in Omaha. But he was associated with a group that had its primary practice in Lincoln. And it said, for the sake of our patients, we can't continue here. You can't care for a patient load that requires 7 doctors, you are 1. We can't support a staff for 7 doctors, you are 1. We must discontinue our practice in Omaha. Here are your choices. You can either join us in Lincoln, we're happy to have you, or you can stay in Omaha but separate from us. We don't intend to try to keep the practice together. It will follow you. Dr. Akkad made choice 2. He stayed in Omaha. On one day, he wore a lab coat that said Nebraska Heart Institute. On the next day, he went to the same office that answered the same telephone with the same number, but was owned that day by a new organization, and his lab coat said Nebraska Medical Center. His compensation was uninterrupted. His patient load was uninterrupted. His file retention, retrieval, and use was interrupted. His equipment was the same, and he went on. Later, Dr. Akkad looked at his contract or contracts. He had 3, but counted 2. One was an employment agreement, simple and straight up. The other was something called a goodwill agreement. He saw those and understood and read them. He overlooked the company bylaws. The bylaws he overlooked both predated and postdated his contract. They were there before he became a shareholder employee, and he ratified them with a new adoption of a new set of bylaws after he became an employee with an employment agreement and also a shareholder, and he did that as a part of the executive committee. The good things this practice had before Dr. Akkad and his partners left included an asset called goodwill. That goodwill was the continuity of the practice. When 6 left and Dr. Akkad decided not to move, the goodwill remained if the practice could continue. It could not by Nebraska Heart Institute because it had no physicians, save 1, with which to populate a 7-physician practice. So Dr. Akkad took at least his fractional share of the goodwill and likely more to Nebraska Medical Center and went on. Later he thought, I think I've got Nebraska Heart Institute. I think I get the goodwill, and I think I get to receive payment for it too. I get A, and I get A again. So he filed suit. In court he argued that Nebraska Heart Institute made a voluntary decision to discontinue its practice in Omaha. It had no doctors. He argues that He was not given an opportunity to remain in Omaha, but was entitled by his contract to do so. The contract says he is to practice medicine where assigned by Nebraska Heart Institute. He says he was entitled to his share of accounts receivable. And he might have been if the practice had continued, but it did not. Instead, it was left with winding down debt, which could only be paid with accounts receivable because it had no continuity. The law favors the equity owners being paid last, after the creditors are paid. If Dr. Akkad gets his way, the equity holders get paid first. He gets his receivables first. That's not what the agreement says, Your Honor.
Mr. Domina, in your briefing, I had trouble following that argument. It was kind of like you seemed to be suggesting that the Nebraska Heart Institute was on the verge of insolvency, and this all just would drive it under if Dr. Akkad got the accounts receivable, and the accounts receivable were necessary in order for the business to survive.
The business didn't survive.
Well, that isn't true.
The
Nebraska
business-
Heart Institute just didn't survive in Omaha.
Well, that's the point.
Well, it wasn't a separate business in Omaha. It was an office.
Well, the legal point, I think, Your Honor, is as I stated, because the logical extension of Dr. Akkad's argument is that every physician would have his right, all the physicians would get out the accounts receivable, they would all go first, and the creditors would be last.
But wait a minute. You know as well as I do from this record that he had to buy into the accounts receivable.
That's because he acquired an interest in an ongoing business. When he left,
So when he leaves, what you're saying is that he gets no return on what he bought.
oh no, I'm not. I'm saying he took with him what he bought in kind, instead of taking it in cash. He had...
Isn't this a contract case?
Yes, it is.
And isn't his entitlement to the accounts receivable determined by the goodwill agreement?
No, not alone. There are two other contractual components, the employment agreement and the bylaws. And without reading those...
Well, let's back up then. The goodwill agreement is essentially, well, it isn't essentially, it is. It's a non-compete agreement.
well,
And he has to do three things in order to be entitled to the payment of the accounts receivable, his share of the accounts receivable, right?
four things.
Well,
Yes, you did
let's
notice-
stick with the non-compete agreement. You can't practice in Omaha anywhere in the state of Nebraska for a year.
Number one.
I'm sure you're going to agree with me. That's invalid.
And we never tried to enforce it.
Okay. The other thing, you can't disparage Nebraska Heart Institute.
That's number two.
And you tell me the third because I
Well,
forgot.
The most important of the three is no notice, and the other is some reasonable cooperation in a transition process. He didn't give
Whoa.
notice.
Okay. Well, I'll check that. I don't
The
think
Goodwill
that.
Agreement's first paragraph requires notice. There is no evidence in the record that he gave any. There is evidence that he wrote a letter about quitting, but none that says he gave the assurances that he would comply with the other three conditions. Now, that may be a technical disconnect, but this is a man who's trying to take his book of business with him, which he did with our consent because it was in the best interest of his patients, and also get paid for his book of business. The contract does not permit that result. The bylaws don't permit it, the employment agreement doesn't contemplate it, and the goodwill agreement is there, Your Honor, for the very purpose of protecting against competition, which presupposes there is a practice in place. There's nothing to protect against if Nebraska Heart is out of business in Omaha. And it was out of business in Omaha. Only Dr. Akkad was in business there. He now wants to be paid while remaining, and we are gone. We think that's a preposterous result, and we ask that you reverse. We think this is an issue of law, and we ask that you remand with directions to dismiss the plaintiff's case. Thank you.
Thank you. You may proceed.
Thank you. May it please the court, my name is Jim McVeigh, and I am the attorney for Dr. Akkad, who is the appellee in the case now before the court. The court's already asked of counsel questions concerning the covenant not to compete and the issues related to that as far as its enforceability. This court's well aware of the long line of cases out of the Court of Appeals and out of the Nebraska Supreme Court that impose three requirements on a covenant not to compete relative to an employee. Those are that it not be injurious to the public, that it be no greater than is necessary to protect an employer's interests, and it not be unduly harsh or oppressive on the employee. Clearly, the covenant not to compete in the goodwill agreement in this case, which prevented Dr. Akkad from working anywhere within the state of Nebraska, does not comply with those restrictions. The fact of the matter is that the rules apply, or the covenant not to compete is enforceable only if it applies to patients with whom Dr. Akkad saw and had personal contact. The covenant not to compete is clearly unenforceable, and Judge Gleason was correct in that determination. The appellants rely extensively on the language set forth in the bylaws concerning payment of accounts receivable. And candidly, as I reviewed both their initial brief and their reply brief, I'm somewhat lost as to that argument. The bylaws say that accounts receivable shall not be considered an asset of the corporation for determining book value of the stock to be redeemed. That's what the goodwill agreement, that's what the bylaws say. If the court reviews Exhibit 52, it is clear that accounts receivable were not included in that redemption analysis, which is the manner and method in which NHI calculated the amounts due to Dr. Akkad for stock. The accounts receivable due and all.
That's the $69,000 for stock, and there's no dispute about that.
None whatsoever.
Okay, so the dispute all arises out of the non-compete agreement.
Correct, Your Honor.
Okay, so tell me what your best argument is with respect to Dr. Akkad's failure to provide what I read as a written notice that basically says, I will abide by the three requirements of this non-compete agreement.
And counsel's correct, there was a notice requirement in the goodwill agreement.
And the record shows that your client didn't provide that written notice.
Well, the record shows that on February 5th of 2008, Dr. Akkad tendered a letter to Mr. Burnell. Mr. Burnell replied to that letter in his letter of February 8th. Unfortunately, neither Dr. Akkad nor NHI could produce the February 5th letter at trial, so we don't have that. We do have Dr. Burnell's letter of February 8th, in which he acknowledges receipt of a letter of resignation and specifically provides in that February 8th letter to Dr. Akkad that you are not going to get any money from your goodwill agreement. Now, that letter is somewhat confusing in that it talks about you failed to execute the goodwill agreement. Clearly, Dr. Akkad did sign that. There is no reference in Mr. Burnell's letter as to whether Dr. Akkad agreed to not impugn the character of NHI or its physicians and hold information in confidence. You asked.
Well, the testimony is that there's no dispute that Akkad complied with those two things.
There is no dispute.
Okay.
But there's no evidence, since we don't have the letter, we can't provide that to either the trial court or this court to show what Dr. Akkad had in that letter and that he agreed to comply with all three of those conditions. I would suggest to the court
I think it wasn't his testimony that he didn't remember whether he put the notice piece in his letter of February 5th.
Well, he knew he had a resignation piece in there.
Right.
He did not know and could not testify at trial whether he spoke to all three of those issues. He talked about the goodwill payment or the accounts receivable payment, and that's supported by Dr. Burnell's reply that we're not going to pay you that. There is no evidence to suggest that he specifically mentioned in his February 5th letter I will not impugn the character of NHI or its physicians, and I will hold information in confidence. It's true that those are not, we don't have anything in the record to substantiate that. I would suggest that there are a number of cases that talk about substantial compliance with conditions preceding to right to recovery, and given the facts of this case, that Dr. Akkad substantially complied with the notice provision. I also think, Your Honor, as to that issue, it's unreasonable to suggest that in the face of Mr. Burnell's letter of February 8th, saying you're not going to get your payments under the goodwill agreement, that Dr. Akkad then after his termination and within 30 days of redemption, is going to send another letter saying, hey, wait a minute, I know you already told me I'm not going to get my goodwill money, but let me comply with this 3-tier notice and provide you another request for payment. Again, our position is that the February 5th letter, although we don't have it in evidence, what constituted substantial compliance with that requirement.
Okay. Would you address the argument that Dr. Akkad did not relocate to Lincoln?
Well, and I think I quoted in the brief, Your Honor, that evidence is in dispute. I know Mr. Burnell, on behalf of NHI, said they made such an offer to Dr. Akkad. Dr. Akkad testified, I think Judge Gleason asked him the question, were you offered a position in Lincoln from January 14th until your date of termination of March 15th? And Dr. Akkad indicated he had not been offered such a position. There is no evidence other than the conflicting testimony of these two witnesses to suggest that any position was offered. Certainly, Mr. Burnell's letter of February 8th doesn't reference such an offer. There is no other type of email or other communication saying, Dr. Akkad, you're welcome to come to Lincoln if you'd like to do so. So, as the trial court being a finder of fact, and that factual determination being made that no such offer had been extended, I would submit to the court that that factual determination is subject to review, but only upon some abuse of discretion by the trial court. There simply is no evidence in the record to suggest that there was such an offer made. The other issue that the appellants raised in their brief is the doctrine of mutuality. The premise of that is there were not other options or items that Dr. Akkad was required to adhere to as part of the goodwill agreement, and therefore if the covenant not to compete is deemed to be unenforceable, the entire goodwill agreement needs to be thrown out. As the court, Judge Stevens, you pointed out, there were other obligations imposed on Dr. Akkad by virtue of the goodwill agreement, the obligation to not impugn the character and not to hold information in confidence, and again, the evidence is in dispute that Dr. Akkad did comply with those other obligations. Because of that,
isn't there evidence in the record that suggests at least that the transaction between Nebraska Heart Institute and Nebraska Medical Center, where on March 14th it was still Heart Institute, March 15th it's the Medical Center, that part and parcel of that was that Akkad would stay until the 14th, and then on the 15th he would sort of transfer over with the records and the equipment, and that Nebraska Heart Institute was paying the Medical Center $25,000 for them to take this over.
right, and in addition, and you're exactly right, Your Honor, the fact of the matter is even Burnell's letter of February 8th references the fact that Dr. Akkad is going to be working for NMC on March 15th, the day after his employment terminates at Nebraska Heart.
And he also gives Dr. Akkad some nice little warnings about what he has to do between February 8th and March through the 14th about fulfilling his professional obligation will be considered breach of your contract. So obviously on February 8th they thought he was still in compliance with his contract. They're telling him not to breach his contract.
And there's no evidence between February 8th and March 14th that he somehow fell foul of that language, Your Honor. It is NMC that purchased the practice from Nebraska Heart Institute, or acquired the practice. It wasn't Dr. Akkad, and for some reason we seem to get hung up a little bit in terms of Dr. Akkad having his cake and eating it too in terms of that issue. I think that deflects the attention away from the obligations imposed on NHI under the Goodwill Agreement, and really confuses the issue with matters such as NHI's ability to pay creditors. Again, I point out to the court that there were 41 locations across Nebraska where this company did business, including offices in Lincoln and Grand Island. And the fact of the matter is that this is one office out of many, certainly does not constitute some attempt or some fact pattern in which NHI is destitute or that Dr. Akkad receives money in advance of creditors. I think that argument's misplaced.
Your time has
Thank
expired.
you, Your Honor.
Thank you. How much rebuttal time remains?
It was a negative purchase. NMC got money it didn't pay, number one, and number two, build a practice, give a notice that you won't say something bad, keep the practice, and get paid for the goodwill? We don't think so.
Thank you. All time.